connection before was bad. I was getting ready to send you a message to tell you to log out, and you did that, so. All right, we're good. All right, Ben, you want to go ahead and start us on a record then?
Yes, sir.
Recording in progress.
All right, this is case number 21 CR 144, State of Ohio versus Joshua L. Moore. This hearing is being conducted by Zoom. Mr. Moore is appearing by Zoom from, I believe, the probation department. His attorney, William Armentrout, is appearing from his office. The assistant prosecutor, Adam King, is appearing from his office. Mr. Armentrout, you and your client are both agreeing to have this matter conducted by Zoom rather than an in-person hearing.
Yes, we are.
You're agreeing with that, Mr. Moore?
Yes, sir.
Right, we had a hearing for a pretrial yesterday, and the parties indicated that there was an agreement reached, and I have that here, I believe. Let me see where. Well, let me hold on a minute. I need to open that up. I thought I had it open, but let's see here. All right. There it is. All right. So that is a plea form, Mr. Moore, that was just emailed to me, and it has your name, case number on there, and it says that it's a plea of guilty. You recognize and see that form, okay?
Yes, sir.
All right. Now I'm going to go clear down to the end of the document, and right there on page 3. There's a sentence where my cursor is. It says I entered this plea voluntarily, and below that, there's a line printed under which the printed signature defendant. Is that your signature there? I'm looking at with my cursor.
Yes, sir.
All right, and I know you had an appointment to see Mr. Armentrout this morning, and did you just sign this document this morning?
Yes, sir.
At his office?
Yes.
When you signed it, did you understand it was agreement to plead guilty, which means there won't be a trial. The next step in your case will be a sentencing hearing?
Yes, sir.
Now, do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
You and Mr. Armentrout have been talking about this before he came to his office today.
Yes.
All right. Are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
All right. And by the way, if at any time during this hearing you need to talk to Mr. Armentrout, since you're not in the courtroom next to him, just tell me, and I can put you and him into what's called a breakout room where the two of you can talk. No one else will be able to see you, period, okay?
Okay.
All right, now go back up to page 1, and it says that you're going to withdraw your not guilty plea to count 1. You're currently charged with 2 counts of breaking and entering and theft. This says you're going to withdraw your not guilty plea and plead guilty to the first count, breaking and entering under 2911.13a, a 5th-degree felony. Further states that you understand that the maximum penalty for that could be 12 months in prison. There's a minimum of 6 months if prison's imposed. There could be a fine of $2,500. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else, Mr. Moore?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
I'm on probation in Stark County. I call every Monday.
All right, and what is that for?
For $2,500 cash. That was in a car that I bought.
Pardon me?
Felony theft.
Theft, okay, all right. So, I don't know when how long have you been on probation up there?
A month.
Okay. So, that offense wasn't committed then, all right. So, then the plea here would not have any effect on that, that's what I was getting at, because if you commit a felony while you're on community control, then it could be grounds for revocation. But since these cases have been pending at the same time, that shouldn't be a problem. However, if at some point in the future you should be sentenced to prison in this case and the Stark County case, those cases will be served consecutively, meaning one after the other. You understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense I can impose what's called, well, let me back up, post-release control. In the event you should be sentenced to prison and serve a prison term, then the law provides that the adult parole authority, as part of that sentence, could decide to put you under post-release control supervision for a period of up to 2 years. They would set the terms and the parole officer would supervise you. And if during that period of time they found that you had failed to comply with those conditions, they could return you to prison to make you serve an additional period of up to, in this case, half of your prison term, which is 6 months. If the maximum is 12, that would be the most it would be, or one or more violations. But if you commit a new felony while you're under post-release control, then in addition to whatever sentence the judge in a new case can impose upon you, the judge can also sentence you, in this case, or for committing that offense while under post-release control in this case, for an additional period of 1 year, whatever time is left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served in the second sentence in the case. You understand that? So, now under the law, I'm not required to sentence you to prison for this offense I can impose is called committing control. And since you're familiar with that, committing control is basically probation. It means that instead of going to prison, you're put under the supervision of the probation officer. Your term set by the court, in this case, for up to 5 years. Now, if during that period of time the probation department felt that you were not complying, they would violate and notice that or serve a copy on you. You would have a hearing and be entitled to be represented by an attorney at that hearing. If the outcome of that hearing was that you failed to comply, at that time the court would revoke your command control and then sentence you to prison for 12 months and fine you $25 or not. You understand that? So, alright, now the charge in this case alleged that on about June 14, 2021 in this county, Bobby Lee Clifford and you did knowingly by force of deception, trespass, and an unoccupied structure to put a barn, lean-to, purpose to commit therein a theft offense of $5 section 2913.02A1 or above. A violation of 2911.13A Iowa Code, which is breaking and entering a felony with a possible prison term of 12 months and a possible fine of $25. Mr. Moore, you understand what it is the state sent you did, when, where, how they elected you did? Yes, sir. You understand the possible penalties for that offense? Yes, sir. Now, we discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible questions you try to raise in trial, possible conflict of trial with your attorney. Yes, sir. And you're satisfied with his advice and confidence in this matter? Yes, sir. Are you under the influence of any types of drugs or alcohol at this time? Yes, sir. Are you taking any prescription drugs? No, sir. Has anyone threatened you to make you plead guilty here today? No, sir. Now, on page 2 there's a couple of lines there. You should be able to see that are bold with underlines. See those? Yeah. Alright, they read as follows. Defendant shall not plead guilty to count 1, state was dismissed count 2, state defense trying to recommend committing control, then agrees to make full restitution. That's your understanding of the agreement? Yes, sir. Does anyone want you to think other than that issues to plead guilty here today? Yes, sir. And Mr. King, we have an amount of restitution? No restitution, Your Honor. Okay. Alright. Now, Mr. Moore, under the law, the matter of sentencing is reserved to the judge, not to the parties. So even though there's an agreement between the state and you that you should receive a committed control sentence, I'm not bound by that recommendation. So once I receive all information that's presented regarding the matter of sentencing, I decide that's not the correct sentence. I could impose a sentence of prison in order to I thought that was the right thing to do. You understand that? Yes, sir. Right now, do you hold any type of license or certification from any state agency or any trade or profession? No, sir. Right now, there are certain constitutional rights you must understand before I plead guilty. First of all, you have the right to have counsel. If there are problems with the represents you, not simply work case but any defense might be able to do under the law that you like Constitution, you have a right to have a jury trial. Doesn't matter if there's 12 people we selected. For a group of citizens that are selected for jury to be under trial, they are, if those people would have to live in this county. Now, after those 12 are selected, the evidence will be presented, they be instructed on the law. And then the judge, or then the jury would have to decide by a unanimous verdict, meaning have to agree, as to whether or not the state proved guilty of proof beyond a reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up in writing the right to have a jury trial. And in that case, you would have to call a court bench. And that means that the judges will hear the evidence and apply the law and make the decision whether or not the state proved guilty of proof beyond a reasonable doubt to the jury. You understand that?
Yes, sir.
Now, Mr. Moore, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. What that means, the witnesses against you have to come in court and testify whether you.
I just went to sleep. I was sitting here like this, and he went from real loud to what he's mad.
You understand that? Right, under the Constitution, you have a right to use the power of this court to call force witnesses to come in court to testify for you, just like the state. So if you have witnesses you're not certain why you come in voluntarily, your request court issues court orders called a subpoena, and that would force those witnesses to come to court, be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination. What that means is that you cannot be forced to give evidence or testify in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can. You make that decision. And if you decide that you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person. And no one's even able to talk about that, except in one situation. That is, if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is on the state. In fact, under the law, you're not even required to present any evidence in your own defense at trial. Now, you may, but you're not required to. Whether you present any evidence in your own defense or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charge by proving beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally, you entered a plea of not guilty, Mr. Moore. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or revoked all the rights that I just described for you this morning. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea, in that it admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives or gives up all of the rights that I just described for you this morning, except your right to have an attorney. Because you always have a right to have an attorney no matter what your plea is. With that exception, plea of guilty would waive or give up your right to have any jury or court trial. Waive or give up your right to confront witnesses against you and cross-examine them through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. You would waive or give up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. You would waive or give up your right to, right to require the state to prove your guilt and prove beyond a reasonable doubt and your presumption of innocence. Because if you say you're guilty, the state doesn't have to prove your guilt. It also subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you may have had up to this point in the case. Now, if I sentence you to the maximum sentence or under other certain limited circumstances, you can file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir.
And are you a U.S. citizen, Mr. Moore?
Yes, sir.
And you're entering into this agreement to plead guilty voluntarily?
Yes, sir.
Right now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand?
Yes.
Do you have any questions about the plea agreement?
Yes, sir.
You understand?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if we enter that here today?
No, sir.
You understand that?
Yes, sir.
Is there there anything you need to speak with Mr. Armentrout about before we go any further?
No, sir.
Any questions about anything that I was planning here? This is your decision to throw the charge and the agreement that we just got over.
Yes, sir.
Right, and that's the charge of the language about obviously for the union, really by force of trespass, not by structure to wit. Barn, lean-to, purpose, there is that pass, as a $5 section 2913.02A1 or a felony, violation of section 2911.13A firearms code, a 50-degree felony charge of breaking and entering, carrying possible prison term of 6 to 12 months and $5,000.
Yeah.
Alright, the court finds on this day of court that the defendant applies all his constitutional rights under the military waiver of the same percentage for Rule 11. Pleas accepted or filed. The defendant is found guilty of count 1, breaking and entering, as charged therein. Count 2 is dismissed. Court will order a pre-sentence investigation by the probation department. Bond will be continued. Sentencing will be set for January the 5th, 2022 at 9 a.m. Since you're right there at the probation department, you'll need to make an appointment for you to see Mr. Fulton, I believe, to do the pre-sentence interview. And continue. Yes.
Did you say January 5th at 9 o'clock?
Yeah, that's a Wednesday, I believe.
Yes, I have a half day starting at 8 o'clock in June before that day.
Okay. Just a half a day?
Yes, sir.
All right, let's do it at 1 p.m.
Your Honor.
Yeah.
At 1 o'clock, different case in June for the rest of the day.
All right. How about the next day, January 6th at say 1 o'clock? All right. January 6th at 1 o'clock. So you won't have to be here. I think your trial date might have been the 13th, 16th. I can't remember this month. You don't have to be here for that. Continue to report to probation under your pretrial supervision, and make sure you see Mr. Fulton or whoever is going to do your pre-sentence interview, because they'll get the information to get to the court that I'll be able to use and make the determination of what the sentence ought to be. All right. Do you have any questions, Mr. Moore?
No, sir.
Anything further, counsel? No, Your Honor.
Is he in good information right now, Judge?
He's there.
Oh.
Yeah, I'm not.
Yeah. So he can make, they'll make an appointment for him now. I know if Mr. Fulton see him today, or he may need